Working for the Council of Europe. The Council of Europe has organized this workshop. We're just 10 minutes ahead the schedule. We have 1 hour 30 today to discuss privacy issues. And I will first give the floor to Maud de Boer-Boukikio, Deputy Secretary General of the Council of Europe.
Thank you very much, Sophie. Good morning, ladies and gentlemen. It's my pleasure to open the workshop focusing on strengthening the protection of cross-border internet personal data. This workshop, organized by the Council of Europe with the contribution of a number of key experts, aims at feeding the current modernization process of a privacy backbone convention, the Council of Europe Convention for the Protection of Individuals with regard to automatic processing of personal data. A very long title, and therefore we are actually used to refer to this convention as Convention number 108, since it was the 108th treaty which was drafted within the framework of the Council of Europe. And this year we will be marking the 30th anniversary of the convention. Its purpose, which is to secure to every individual the right to privacy, remains as valid today as it was 30 years ago. The increased use of internet, the borderless nature of data flows, and the development of new technologies lead to a new data protection challenges. This includes potential new risks for the protection of human rights and fundamental freedoms, which we are bound to address. This is a growing global concern calling for a global consideration of privacy issues, and I'm therefore pleased to highlight that Convention number 108 provides indeed a suitable framework for this. The global outreach of the Convention is already in its genes. 30 years ago, a number of non-European states, Australia, Canada, Japan, and the United States, participated in the drafting process. But these genes have expressed themselves, influencing legislations and policies around the world, and Uruguay has just been invited to accede. But sometimes genes undergo transformations to allow for better adaptation to a changing environment. One of the main advantages of the Data Protection Convention is its technological neutral language, which makes its provisions still valid today. However, the information society revolution is triggering evolution, and we are currently reviewing the Data Convention so that it can become even more relevant and efficient. We are therefore in a defining moment worldwide. Similar review exercises are currently being carried out both at European and international level, namely by the European Union and the Organization for Economic Cooperation and Development. An important feature of these discussions is their multi-stakeholder nature. Privacy and data protection are everyone's business. Regulators have to discuss those questions with all parties concerned. Ladies and gentlemen, Chinese philosopher Lao Tzu said that the reason why the universe is eternal is that it doesn't live for itself. It gives life to others as it transforms. This is our vision of the evolution of our Data Protection Convention, which I trust you share. But this is your platform, and time devoted to this kind of exchanges is limited. So I therefore prefer to give this precious floor back to you now. Let me just finish by encouraging you to make use of this opportunity to put questions, raise issues, and propose answers, allowing us to build a strong instrument capable of addressing all present and future challenges of data protection. I thank you for your attention, and I wish you a fruitful exchange.
Thank you very much. Let me now introduce the panelists that will be exchanging today on the topic. We have first Cornelia Couterer, Director of Regulatory Policy for Microsoft. I'm ashamed to say that despite my Polish name, I will just present Kasia as Kasia and not to give her full name because the pronunciation wouldn't be correct. So Kasia is the Director of the Panopticon Foundation and EDRI affiliation. organization. Then we have Anton Battesti, is a policy manager for the French Data Protection Authority, called the CNIL. And finally, we have Norbert Bolo, systems analyst and technologist for FOSS, which is free and open source software. Let me also introduce Sorina. She's there. She's a remote moderator, so she will feed in the discussions if we have remote participants asking questions. And Alessandra Pierucci, co-moderator, who's also Council of Europe staff. So as this was said to you in the opening, we are modernizing our convention. It's 30 years old. The process has well started. We had a public consultation with quite a lot of feedback from all stakeholders. We've digested this feedback. We are now going to draft some proposals, and the idea was here with all stakeholders, exchange with you on 3 precise questions we've identified we would like to share with you. The first question being the need for new principles. I'll give the floor to Alessandra to present this.
Thank you very much. Is it? Yeah. As Sophie was saying, in the process of modernization of Convention 108, the consultative committee started thinking about a possibility to introduce new principles. We know that new technologies have deeply changed the scenario we are living in. Challenges have been raised with regard to data protection, so the introduction of new principle may somehow rebalance this scenario in order to keep high the level of protection with regard to data protection. So I would mention only 3 of this principle. First of all, the principle of minimization. Secondly, the privacy by design principle. And thirdly, the accountability principle. I'm just going through this principle very, very quickly. When we speak about a principle of minimization, what do we refer to? Okay, we first of all know that Convention 108 already says that personal data should not be excessive, should be pertinent, which is somehow already a kind of representation of this minimization principle. But the principle of minimization wants to go a little bit further to say that a collection of personal data from the very beginning should be minimized. So no unnecessary personal data should be collected. Regarding the accountability principle, which has been actually considered also in other international and European forum, for instance, the European Union level, as well as in the international standards of data protection, which were adopted in Madrid. It basically means that data controllers must be responsible for the processing they carry out, and moreover, they must be able to put in place let's say, practical mechanism in order to show to competent authority, namely data protection authorities, that their policies are in compliance with data protection rules. Thirdly, the principle of privacy by design, which basically means that technologies, devices should be at a very early stage at their conception developed in with the kind of privacy-friendly perspective. So I would like to pose these questions to our panelists. What do they think about the possibility to introduce these new principles? Do you think that it would be a too cumbersome thing to do in a convention? Or do you think that it may improve a new vision of privacy where stakeholders are involved at the very early stage of the conception of technologies, of devices, of data processing, and then they keep, they need to be involved in their responsibility during all the processing of personal data, as the principle of accountability shows. So thank you very much.
Whoever of the panel would like to come into that first question about new principles? Cornelia?
Thanks. First of all, thank you very much for letting me join this panel. We had a very active preparation session already of 1.5 hours, so we feel like we're well prepared to go into the discussion and let also others participate here. The three questions, and let me move a little bit to put this in context, what I'm going to say. We are looking obviously not only at the revision of the 108 convention, we are also looking at the OECD guidelines that are currently revised. We are looking at an APAC revision of data protection with, in particular, cross-border privacy rules. And from my perspective, being a European, we are also looking, obviously, at the revision of the EU legal framework for privacy. And in that context, there are two common denominators. Our global flow of data has fundamentally changed. Not only is data flowing, actually it is the people around the data which are having specific expectations. It is the people who are mobile and the people who want to be able to have access to their data whenever and wherever. Also, the service expectation is increased, and services have adapted to that, going with the sun, so their services are available 24 hours a day, 7 days a week, and that is only possible if you have the processing of that data according to the help desks wherever they are. So all these things are fundamental changes in how we treat and process data. On top of that, cloud computing is obviously just increasing really this amount of data that is processed and how data is really globalized. So the three questions from our perspective are inherently combined, and new principles are necessary, but the necessity of the principles, which I'm going into detail in a second, are going along with a need for simplification of the laws that are encumbering that. So there needs to be, and that's the technical discussions around other areas which are not covered here. The principle of accountability is a good principle if that allows companies to be more efficient in how they process the data. So adding such a principle seems to be very important, and is in particular a principle that is currently very much discussed in the APEC discussion around cross-border privacy rules. It's actually the fundament of these new rules. So welcome from our perspective, and there is a number of discussions going on to really come to terms in what it really means in the former Gateway project, now called Paris project. The privacy by design principle is a welcome principle from Microsoft perspectives. Microsoft has encumbered the privacy by design principle already since 2002, when we started our Trustworthy Computing program. This program has developed a so-called security development life cycle, which enforces in the development of our software specific steps for our developers. That is, first of all, the training of the developers, make them aware of privacy principles, but also having to apply certain mechanisms while they are developing the software in order to make it privacy enhancing, privacy friendly. So there are steps done. This is a program which we have designed, which is applicable to all our software. And we have made this security development lifecycle program also public for other companies to apply it.
Okay, thank you, Sophie. I might add to what Cornelia said from the civil society perspective. We very much agree with your perspective, which is good news, I guess, for working out new principles. Whenever business and civil society meets it means we can move forward. What we see as an NGO as the main challenge here that needs to be addressed is certainly what has been said, reformulation of cross-border data flows, which are ubiquitous and unavoidable from both business and client perspective. We have business-to-business cloud computing development. Of course, it's cost-cutting and sending data to India and everywhere around, which we will not prevent. But also from the client perspective, as Cornelia mentioned, clients want their data to be available wherever they go, which means, again, the necessity of using the cloud. But another problem in that context we have identified is the issue of consent. I mean, how do we actually get to informed consent in that setting? Can an average individual going online comprehend the complex system which is being used to process her data? Can we really achieve informed consent online? And even if we have the informed consent, if there is no viable alternative to a service that a customer uses, if she or he cannot go anywhere else, is the consent, the thing we really want to justify data processing? So in that context, I think the principles we mentioned, data minimization and proportionality, are absolutely fundamental. This is the only way of achieving proportionality in data processing. If we have a consumer agreeing to data processing in the context I mentioned, where it's not informed or it's not voluntary, we get to a situation where data is being processed beyond control of an individual. So the only way to move forward, in my opinion, is to impose higher principles on business companies. I will talk about governments in a minute, so it's not only business that is in trouble, in order to prevent that excessive processing from happening. And we should be clear about the fact that the consent cannot validate excessive data processing. Another big problem is certainly governments that exchange a lot of data on a security basis. They use existing exemptions. So effectively, in our opinion, the data being exchanged for security reasons is not protected, is done excessively. There is no proportionality in the system. So we need to consider how to convince governments, how to convince law enforcement agencies to apply essentially the same principles that business tends or wishes to apply, which is, I would say, the biggest challenge, not only for 108 Convention, but also for the big reform we expect in the EU. From the insiders talk, we hear that the business can really work on that, but nobody knows how to convince the government to accept the same principles for so-called third pillar issues. So I would say this is the main challenge for all of us to discuss today, and definitely the data minimization and proportionality should be applied by secret services agencies the same way it should be applied by international corporations. Thank you.
I would like to react just a bit first on what has been said about the problem with consent. I think there's an even bigger problem with that kind of data problem, which does not live so much in a single data set, like, for example, a single email envelope data set, which essentially says that I am sending an email to, say, somebody at Microsoft. What does this tell about me? Not so much, but when you take all my data together, then it says a lot about me, very much so. And I have never given my consent to processing this big set of data, but it could be argued that I have, every time I send my email, given my consent that this email envelope data set has been processed, because without processing it, you cannot get the email to the destination. So I think we need to add a third category of data protection issue in addition to the processing of data within a country, subject to the data protection laws of that country, and in addition to the cross-border transmission of data. There is this kind of data set which does not live anywhere specifically, where the privacy problem comes into existence through the fact that data about me exists in many places and nobody really can prevent anyone from putting that data together. Who is responsible? Who is in charge of protecting that data? And then when we get to privacy by design, which is really the only feasible, practical approach to prevent that kind of data from eventually leaking out and creating huge problems, at least for members of some minority group, and it's impossible to predict right now which will be the minority group that will be attacked next. So how can that be done? I would like to react a bit to what my colleague from Microsoft has said. And now, I'm on the record of being a strong critic of Microsoft. But in this particular point, I'm not going to criticize Microsoft because they are actually pushing ahead in that area, and that's good. But I think we need to move this to a higher level, out of the Microsoft world into the IETF and ISO-IEC world of really creating standards that will be used by everyone. So I would suggest to the Council of Europe, to national governments, send technical people to these standardization groups. Even one person who understands what is going on, he can make a huge difference. These groups, they act by consensus. So one person there who says, we need to protect this personal data of who communicates with whom. There must be encryption when the envelope data is transmitted. For example, that will make a huge difference. And really, if it's not the governments protecting the citizens, who will do it?
Yes, good morning. First, I want to thank the Council of Europe for allowing me to speak on that panel. The first thing I want to say, just to really frame the subject, is data protection is, from a CNIL point of view, is above all a question of human rights. Because information is power. Information you have on people, whatever you are, a government or a company, give you, whatever you want or not, some kind of power on it. It is sometimes considered to have this kind of regulation maybe a luxury, or DPE are just here to annoy people, or it's not the case. The thing is, the first goal is to protect the rights of the citizen. That's why all this legislation has been created now 30 years ago. 30 years ago, even before my birth. So personal data, I am 29. The thing is, if you look at our French Data Protection Act, the Article 1 is saying computing must respect human dignity and the human rights. When you're talking about human rights, you're talking about empowerment, that you give something to the people to protect them against an abuse of power from the government or someone else, maybe a company, for example. So when you're talking about principles, many have been said, and I'm quite agree, we need to find new principles. But the thing is, we have really good principles now, since 30 years. And the beauty of that principle is they are technically neutral and are still applicable now, as it is the same for our human rights acts, whatever they are. In 1789 in France, never ever imagined the internet or imagine radio communication, television, but those people just said, you have the freedom of speech. Okay, freedom of speech at this time was newspaper, books, and then after is still applicable on the internet 200 years after. So we need to keep those principles and to find a way to enforce them better. But it's something alive, so we can maybe improve them or add something. What we can add, for example, is a right to, I don't know if it's the right word in English, but right to portability, to say you have your own data somewhere, and you want to change your, I'm talking about, for example, social networking. You want to change because you think the Facebook is old-fashioned now. There is a new thing. That will happen. And I just want to say, I don't want to be blocked on something. So it's the same thing that when you change your mobile operator, you want to keep your number because everybody knows your number. It's very complicated. So this is a way maybe to give a little more power to people on their personal data. The only, the following, principle is, it's really debated, so I don't want to launch something here. It's the right to oblivion, a right to be forgotten. I just want to say it's maybe a way to frame a question or a need from our citizens that today they realize that their personal data are everywhere on the internet, and it has some consequences on their professional life, for example, and they calling us sometimes desperately to ask us to do something because they don't want those information to have serious consequence on them. The problem with the internet, as you all know, is global, immaterial, and with copy and paste, this information will duplicate itself forever. So I think it's not a solution, magical to say, right to oblivion. But this concept is at least a way to frame what it looks to be a real need for citizens. And my last point will be on accountability. We think that we need to find common grounds with a private company. And accountability is a way to build a bridge between data protection authorities and companies, because if we agree on processes, and it will be maybe safer and better for companies because they will know that what they have done is okay. So previsibility is very important for business, so they will continue to develop their software. So be sure that being a DPA is not to annoy any company. It's just to be sure that our people, they just know what they're doing, and we're talking about consent or many things like that. But that's the point. Accountability is maybe a new tool we can use to not to sanction all the time, but to prevent. And in the end, it's better for the citizens, consumers, and for business, I think. Thank you.
So thank you very much for your very interesting suggestions. You gave answers about the possibility to introduce these 3 principles I mentioned, but you also mentioned new further principles. We heard, for instance, that a simplification perspective should be considered in the introduction of these new principles. We also heard about the problem of consent, which has a lot of criticalities, as we know, on the internet. We heard about the cross-border transmission, which should be an important perspective to be considered too, and also about the portability principles and the right to be forgotten. So having all these principles in mind, I actually invite people from the audience to give their comments, and of course from remote participation there are suggestions, questions, please let us know. Thank you. Sorry, can I also ask you to introduce yourself firstly? Thank you very much.
Yes, thank you. My name is Ganesh Denso. I'm from the German government, from the Ministry of Interior. And I have a question, because we are talking here now on an international conference, and your statements came from more or less European perspective, I think. And in the European Union, we have a very important rule in our data protection directive. It's the Article 25, and it's about transmitting data to other countries, to so-called third countries. And it is only allowed to transmit data to these countries if there are some special requirements, and there are very strong restrictions on that. And now, if it comes to the internet, we have a problem because the internet is a world wide web, and posting someone in the internet, blogging something, or telling stories on your own homepage, it's a transmission of data to the rest of the world. So the European Court of Justice said that this rule is not applicable for the internet. And I think that's a challenge for the European law now, because what are we doing now if internet is becoming more and more important with this rule of transmitting data to the rest of the world? So my question is this rule, if it comes to the internet, still state of the art? And if so, how do we deal with this challenge? Shall we build firewalls do we have to protect our legal framework in Europe so that it is not allowed anymore to transmit these data? It's the first question. The second one is, if it comes to the real principles on data protection. These principles are built in a time just, well, long before we had the internet. And you were talking about envelopes with data packages and these things. So the whole law is looking on each data and each package, and it will follow it. It will say, well, what is the purpose for processing these data, and where does it come from, and am I allowed to send it to another country, and so on. So is this philosophy of looking, well, for protecting the privacy and the private sphere of a person, is it still the right approach to look at each single data and to ask, well, who's the owner of the data, or for what purpose is this data being processed? Or are we now in a different world with the internet, that all these data go more or less together, they build new packages, and is this the second challenge? And do you think in the Council of Europe about these things, about these questions, and also in the European Union? That's my question.
Thank you very much for your question. Please just note that your question about the transborder flow of data will be tackled in the second session of this workshop. Maybe we can also collect the other questions and then answers all together.
My name is Remy Karen. I'm from the Netherlands. And I've been thinking about this personal data thing, because principles are applied to personal data, but what exactly is the set that you define as personal data? And the second question that is attached to it is, who actually owns that data set? I tend to think that I own my personal data, and that I should be allowed to do with it whatever I feel like. So the question is, how do you deal with that?
Thank you. Sebastian Orwengabo from the Singapore Internet Research Center. My first question is related to his protection of data. By who? By the owner of the data, by the data controller, by who? The question seems to be unclear, because in my opinion, if I upload my data on the internet, it ceases to be exclusively under my control. Now I share it with the service provider. The service provider may pass it on. This brings me to the next question of how then can we balance the interests, especially when it comes to responsibilities both of the state, the data controller, and myself. How then do we balance the interest of the state? Supposing I'm a transnational criminal and my data should be protected, and the state wants this data, and the data controller shouldn't release my data. Of course, I wouldn't want. How do we balance those conflicting interests? Thank you.
Hello, my name is Dr. Tom Omawa. I'm from Kenya. I actually teach electronic business. And some of the discussions that you are actually focusing on, I teach my students. I think an element that has been left out is awareness and education. As far as privacy, unless people know what is private, what is supposed to be protected, there's no way, whatever principles we come up with, it's not going to work. One of the things I've found out in my research, I do a lot of research on online security. People are not aware. Even people who use credit cards, people who use mobile phones, they are not aware of some of the risks, some of the information that they are transmitting through all this media. And also they are not aware that data is captured and is backed up, it's stored, and if you do something foolish, that data can be retrieved and it will be against you. So I think we need to include education, awareness, and making people be responsible. That means educating them that this is private data, identifying what is private data, and being able also to look at the other countries, especially the developing countries, where they display even national IDs in the newspapers. How do you protect that? It's lack of actual understanding and it's lack of awareness. Thank you.
Thank you. My name is Avri Doria, just an independent person. In this discussion on the data and the privacy of it, I think two things are getting confounded that confuse me sometimes. And that's certainly when I put my own data on the network and I'm doing some sort of broadcast of it, there's one set of conditions that might need to apply to my data. There's still perhaps a privacy interest and a privacy protection concern, but there is also an act I took in broadcasting that data. On the other hand, there's data that has been given in confidence either to some state agency, to some private agency and such. And that data, having been given with some degree of confidentiality, should probably have a different set of constraints defining it. Both of them seem to be important issues to me, but confounding them makes it difficult. And I'm sure even within that particular direction into two separate piles, there would be subcategorization. The other thing I wonder is when I've given data privately and in confidence to one agency, is there a right I should have of being notified where my data goes? In other words, not only is that data supposed to be private, but if I give it to you, you give it to someone else, or a country actually transfers it across a border, does that become something? And I start to worry about that a lot when I look at some of these cloud services that people buy into with a notion that my data is private. I'm putting it in my own cloud containers. It's not being put out there for any purpose other than my private use. But then that data gets transferred from one jurisdiction to another that has a completely different take on what they may or may not do with my data. So those are the issues that I look at that really start to confuse me when I look at how we should be treating data and privacy. Thanks.
My name is Damir Tomasic from Germany. We have a pretty large debate actually about the end of anonymity on the internet from German side. It's pretty, I have a lot of concerns, and I would love to hear from you what is your position in this case and how this affects data protection and privacy among different countries.
Thank you very much for these very interesting questions. I would ask our panelists to answer this question. Maybe we can start from the very beginning. As we said, the transborder flow of data will be treated later on. So we may probably start with the concept of personal data and the question about who owns personal data. Is any of you who may want to answer? Thank you.
I guess we start from this side again, or is that what you want? Okay. So this was a lot of questions. Shall we stay the whole day and discuss that further? So as I mentioned at the beginning already, I think that the three questions really are inherently linked to each other. And so having these reinforced principles, and a couple of more were mentioned during the discussion, transborder data flow, current frameworks need to be revised. And obviously, again, I apologize for focusing on the legal framework I know best. There are certain rules currently existing in the European Union which have been proven to be very cumbersome and in terms of how to get approval. The safe harbor principle that basically allows for a sort of equivalency test of other countries' data protection. There are very few countries that are actually certified as being under that applicable under that rule, and the other two ways, BCRs and model clauses, are equally cumbersome. And the fact that there is a revision currently, I have no doubt that the Commission is currently thinking very hard in making these efforts more adjusted to our paradigm shift in how data is processed cross-border. Who owns the data? I think the question is a very good one, but relates really to the principle that I think the representative from CNIL has put forward, is data portability. And so basically the possibility, once you've used a cloud service as an example, and you want to shift to another one or want to retrieve the data which you have put on there, that you will be able to do so. And Microsoft has invested in data portability. We do have data portability principles, and there might be the necessity to make distinction between the data you've put on that service and data which was produced during that service. But that is something which we welcome to be part of that. Together with that, I think more transparency is extremely necessary for data subjects to understand what they can do. Data transparency in the terms of use are extremely welcome. Now, there's obviously the problem between more information is not necessarily good information, so our approach to inform our customers is in helping them to digest the information in a certain layered approach, so they can get the higher level principles in how we treat data, but then can go into more details and click into a layered information set that will give them more and more information according to their needs. Awareness education goes without saying. That is a very important part. I think that is something where actually all stakeholders can contribute, civil society, governments, and businesses, in order to raise awareness. It's in the business case certainly a huge issue among small and medium-sized enterprises who do not have, who are not able to employ as many data protection experts, or even not having them at all in their own businesses, and that is something where special attention needs to be done. In the context of developers, I think that's a really big important step, because at the end that links back to the privacy by design principles, where you really need to have the awareness of privacy issues right at the beginning when the services and the software are developed, so that it can be inherent in that development process. And I have mentioned our security development life cycle for that purpose. The question around the principles of my being responsible for what I put myself on the web. We had a very interesting discussion around the right to be forgotten just before we came to this room, and the way how I can eventually enforce that right to be forgotten is very much linked to how laws actually apply, and if you put yourself data on a blog, you are in a way exempted from data protection rules because you are considered to be a household, at least under the current status of the law. So there is different ways of eventually when your picture of that blog gets retrieved to another website and you don't want to have it on that website. I think there is a really different set of rules that applies to that specific situation with its own complexity and challenges, in particular when it comes to how to enforce these rights. But they are not necessarily being dealt with in the same context. And I think this is all I have noted. I certainly missed a couple of things. Sorry.
Thank you very much, Cornelia. You basically went through all the questions. I suggest that... No, it's great. And I suggest that the other panelists do the same. Can I ask you also for brief answers? Unfortunately, we don't have so much time left. Thank you very much.
Okay, I will quickly try to add some comments to this. Thank you, Cornelia, for putting the whole picture. Certainly, the definitions mentioned by many of the speakers in the audience is a big challenge, how we define personal data. What I believe is that we cannot go into a very precise definitions, namely enumerating what is personal data, what is not, because that will lock us, and in next 10 years we will have to revise, or next 1 year maybe, revise the whole framework. So unfortunately, I'm afraid we have to stay with these general principles, which are not very comfortable for business. I can understand that, as well as for consumers who might not know where the borderline between personal and not personal has been set by the law, but there is no other way. Maybe we can rely more on jurisprudence and work with our courts, including international courts, to have more say on that. So I don't see a clear and easy answer or step forward on that point. Who owns the data? I also think that the very basic principle should be that we own our data, and everything that follows, I mean, all other principles are built on that one. I can understand that looking at current landscape, it's easy to think that we no longer own our data. It's owned by corporations, by the cloud, by the government, not by us. And this is what we need to, work on and change. Who should protect data? Who should, data protected by whom? Well, certainly by the authorities, by the state and by the law, enforced by the law, but the protection applies to all entities that process data, be it individuals in certain contexts or be it business. So this is a very general concept, and there is no, easy answer on that one. What is also interesting, and I would like to get back to the broadcasting versus giving data in confidentiality, I do see there is a problem here. I totally agree with Cornelia that this is not so much data protection problem, because when you broadcast yourself, you move more into protection of your works of art and other things. But I can imagine profiling is becoming an issue here. If I put my data on a social network and I broadcast it, I mean, I make it available to the whole network, yes, I cannot call upon data protection to say, please not quote me. But if I discover that I'm being profiled with many other individuals on the basis of what I broadcast by certain companies or by the government, it might be a data protection issue. So I would say yes and no. I mean, there is a different rules, for sure, but we should see some threats here. Thank you.
Yes, just being quick, because we have two other very passionate questions. On anonymity, it's really a tough question, because we face the balance between freedom and security. You have the freedom to express yourself on the internet, but on the other hand, sometimes law enforcement agencies, they need to find some people, like criminals, and they need to find the identity of that person. So this is a challenge for our democratic regulation, how we balance the between. So I don't want to answer that question. We just, as DPA, applies laws, but we don't decide them. And my point is, if I can make a comparison, when you drive your car, there is a, how do you say, ID identification, carte plaque d'identité. I can see the number of this as I am in the streets. But I don't know exactly who is in the car. I don't know the name, I don't know the address, I don't know anything. And I cannot access to the file that would give me this information because I'm not a policeman, I'm not a judge. But a very limited people in our society, because the law says it, can access to this information for very specific purpose. We're talking about proportionality and everything. So maybe it's the path we can find is not anonymity or not anonymity, is in which context and which regulation we can find for some critical information when we need to ensure security of our citizens. Those information can be used. For all the other question, I tried to sum up. Who owns the data? I think, above all, you are the owner of your data. It's your property. Okay? It's your property. Oh, your property, you can, if you take your house, you can rent it, you can use it, you can destroy it, you can do things with your property. But the most important is that you, when you're free to do something, is you have all the information on what you're doing, that you can trust the people on the other side. So the thing is not to forbid you to do something. It's just to say, to create a framework that you can really use your freedom, that to avoid that what you're doing there will be a backfire in the end. So, and the most important thing in this is education. Someone talk about education here, because you need to learn how to drive a car. And when you, even when you have to drive a car, you don't drive a little car. Than, it's not the same thing driving a little Renault than a Ferrari. It's completely different. So education is part of that process to allow young citizens that will become mature citizens to really have the control all of those formidable tools that the internet brings to them. Because if they don't know how to use it properly, it will backfire to them. So it's clearly a challenge if we want this beautiful thing that the internet is to continue to exist on and on. And the last thing about property is you can change your mind, okay? You can rent it, but you can have it back after. Okay, you don't want to rent to your neighbor because he's annoying you. Okay, or you just want to use it for your own. So it's making some images. Just try to see if we can apply this to personal data, and I think so I reinstate that this is your probably. It's not the same thing when you broadcast yourself on the internet because you choose to do it, and the conditions how you do it. And I agree with some spying agencies or law enforcement agencies. So, but in the end, it's better to put all the stakeholders and on. We need a framework for all personal data treatments. So, but after the question is, how do we apply them in this case of broadcasting? How do we apply them in collecting for law enforcement? It's different, but we need some very common principle for all data collect activities. Thank you.
I saw another request for the floor. Maybe you want to react to this? Okay.
Just to...
it's more of a comment that personal... Oh, I'm sorry.
It was just a remark on this idea of owning data. I strongly disagree with what you said, because I think it's not real. Owning information. I mean, if we have a look at the real world or the other world or the former world we had before the internet, if I'm writing a letter to a person, I'm not the owner of the letter anymore with the whole content. If I'm telling someone a secret, I'm not the owner of the secret anymore. I trust the person I'm telling the secret that he's not telling it to another one and creating gossip or something else, but I'm not an owner of it. It's not my property. And if I'm going out and someone's taking a picture of me, I'm not the owner of the picture and the photo. So this idea of owning data is not what we had in former times. And I think it's a very it's a dangerous thought of thinking and telling people you are owner of everything about you.
Just a quick answer. My point was, if I say you are the owner, you are the only one that can decide of what you can do with your information. It's not me to decide. If you have a secret, it's your secret, and you are, and by principle, you are the only people allowed to tell that secret to someone else. It's not in the real world. I won't appreciate that someone reveals secrets about me if it's not me that I've done so. Do you understand my point? Is because but after that, of course, if you freely decide to share your information, you have to face the consequences because you have liberty and responsibility. But the main point is the decision is yours at the beginning. That's most important.
Some other request? Yes, please. Yeah, probably the person who was trying to speak before.
My apologies for before. I guess my comment is somewhat related in that personal data in many cases is interpersonal data, and it involves multiple people. So if we have a meeting that is discussed or that is recorded, or there's a photo of both of us, who owns that data and who has essentially the veto right for that data to be published? And then are we infringing on freedom of speech? Is that an issue? I think it gets complicated very quickly.
Yeah. I just think that, you know, when we talk about data owning, I don't think the term used in most of the European treaties is data controlling, not necessarily owning. So it's about the rights that you have towards that data. If you didn't have these sort of rights, there are a lot of things among the realm of confidentiality which are not covered by intellectual property. Okay, there's no legislation necessarily or convention on trade secrets necessarily unless a particular state has enacted it. And when processors over countries like Pakistan, India, and other countries actually process data, they do it on the basis of a confidentiality agreement. If what is true, what you're saying is true, that, you know, data is not owned, then we would be out of a business in developing countries because we would not be able to guarantee the security of the data that we're receiving. That means that data could be given to anybody by us. And that's a major issue and a concern. So I think we're talking not about necessarily ownership, but we're talking about rights that are connected to that data. So I completely take the point made by I think it's the French government, sir, if I'm correct. And you know, when there was another point made that this never existed in earlier times, I don't know about that because at least in the common law countries, the Official Secrets Act, the biggest misnomer owner of data was the government. And if you disclose any information that the government had that you got as a cabinet minister or as an official working in a government, you could be prosecuted and get put into jail. Now, whether or not those sort of rights are extended to business or not is a different question, but it's not true to say that this sort of right of control of data didn't exist earlier.
Question, please.
Thank you. Matthias Dreimer from the Austrian government. I just want to come back very briefly to that, what my German colleague has asked, and also your reaction then. I think that you were very right in saying it's not so much about the ownership of data, it's a question of what your constitutional court in Germany had developed. It's this informational self-determination, what happens. And coming back to this informational, what happens to my data, I just wanted to ask, how does the panel see this in the situation of children? Because the Council of Europe already in 2008, 47 member states declared and said that other than in the context of law enforcement, there should be no lasting or permanently accessible record of the content created by children in the internet. And the member states were invited with relevant stakeholders to explore the feasibility of removing or deleting such content. So I was very much involved because I was chairing the steering committee at this time, and I'm frustrated about this because when I ask my colleagues about the evaluation and what has really happened, nobody really knows an answer. So I just asked that, what advice would you like to give us in the CDMC, for example, the steering committee that has developed this, that government and stakeholders really take an action on this declaration? Thank you.
Any reactions about this? And then we also want to hear Norbert answers to the previous questions. Thank you.
Just quick reaction on the ownership issue. I would like to defend this concept, but stressing that, of course, it's not the same notion as owning a table or a chair, because information is something different, and you are very right by showing that processing information is a different thing, and it's a unique in itself. But I do think we have no other analogy in the law, and it's a very good starting point. And then we have to consider exemptions, like with a car or a table. Your government may come and say, we have a war, please give us your table or your car. With information, we simply have more and different exemptions, like giving you a right to express or right to document important events. Very often it will be exempted from data protection on the grounds of something else, on the grounds of public security, on the grounds of right to information. So I think by remembering that we do have different exemptions and different balancing here, the very concept is a good one, because without that very concept we get lost. Seriously, we get lost thinking, well, I have no other rights, no other basis for my rights to claim what has been called my data autonomy, or the right to determine the purposes for which my data will be processed.
Yeah, I totally agree with that. I think that you have to see that in that given context, but I understand the concerns around why you want to see a distinction. But that is a difficulty in all of those notions on these new principles, and therefore I think it is very important to sometimes remind us the context in which we would like to see these be applied. That brings me to the child safety question, which is a very interesting one, and it also relates back to the difficulties around consent and children giving consent. And I think if you look around the EU member states, DPA's interpretation, which to a large extent is found back in civil code principles, it already shows the difficulty in defining these things. In a practical matter, there is a lot of self-regulation going on currently within the EU to enhance privacy for children and other things, by the way, really safety for children online. And I'm certainly trying to talk to you about this more specifically when this panel is over. There is also it's a very difficult one to work on. We have, for example, parental controls that give the educators some way of helping their children to control their behavior online. There is an educational part which is very important, where in particular schools come in. And I think there has been a tremendous effort by a number of NGOs in cooperation with businesses to really go into the schools and educate children around the risks when they are online, which goes to that.
So immediate question, but how does industry see this recommendation or this declaration that data of children should be deleted after a certain time automatically?
I think in the first place, in certain circumstances, there is agreement, for example, when data is collected for advertising purposes, that there is, for example, agreement among the advertising industry that there is no segmentation of children, so there is no data collection in the first place. So this is, for example, a very concrete example where the protection of children is safeguarded. Parental controls is another thing. And then many of the services have age restrictions or age rating schemes, which help, again, the parents. It's certainly a complex one, and it goes back to the identity, because very often you don't necessarily know whom you're dealing with as a service provider. So it is not an easy one, and the current discussion, I would invite actually more member states to participate in this EU discussion, which, as far as I can see, is only happening from the UK currently.
Thank you very much. Norbert, I think you have a huge quantity of questions you have to deal with all together. Thank you.
Thank you. I also was planning to criticize the concept of ownership of data, even though I really like it in a way. But I think it should be more accurately phrased as each person having a bundle of dignity rights that, unlike property, cannot be sold. That's the first distinction that I would draw. Otherwise, there will soon be companies claiming ownership of my personal data, and that is not something I want, even if they claim they gave me money for it. No, it's a dignity right that cannot be sold, cannot be traded. That is something that I should be allowed to have as a human being. So this concept of ownership has its limit, even if it can inspire it to good ideas. But then I think we should look closely at these ideas and really make sure they make sense, even if we drop the word of ownership. Just as a very quick aside, as a free software person, I'm very, very familiar with how thinking about ownership, like an ownership of software, can become. Because there's this huge word that many people cannot see if they just think in the intellectually property way of thinking, which limits in some ways. So I think we need to move to a different framework of protecting this human dignity, and I would suggest that it is more appropriate to think about a framework of responsibilities. Responsibilities which, of course, must be designed with the goal in mind of protecting human dignity and human rights, and which must be designed, and this is very important from my perspective, for compatibility with citizen freedom in every respect. It does not help me so much if somebody designs data protection into the software that I use, but then I lose freedom to change my software. As a free software person, this is unacceptable to me, especially because I love free software so much precisely because I can use it to protect my privacy.
Very much for your very exhaustive answers. I will give the floor to Sophie, who will introduce the next session of the workshop.
Yes, thank you very much. We've seen the issues are imbricated one into another. We started with new principles. We already had those questions about transborder data flows popping up. There is a strong link concerning this regional focus that has been mentioned several times. Maybe I would like to underline that I don't think it's that relevant. Okay, the Council of Europe has organized this event. You have European panelists there at the table. We're modernizing our convention, but as it was said, this convention was drafted at the time with non-European member states. It's open to non-European member states. We will have Uruguay now invited to accede to the convention. It will become the first non-European party. And most of all, we're modernizing it now with this global mind and no better forum than the forum today to exchange together, because those are the issues which we've heard Kenyan representatives saying they have the same problem. We need to raise awareness. So we need to discuss this all together. So precisely about the transborder data flows, linking it back to the convention, because that's for us our working basis. The convention 30 years ago did not foresee anything in terms of transborder data flow. It just focused on the free flow of information. We didn't want our convention to be an obstacle to the free flow of information. So that was the starting point. And then in 2000, we realized that some things need to be done about that. And there was a provision that basically specified that you can have those transborder data flows when the legislation of the receiving party of the other member states is adequate, is in conformity with the level of protection we're setting. So that's the basis. Is this still relevant? Can we still speak about transborder data flows? We've heard terms like ubiquitous, instantaneous. How can we effectively protect our data, knowing that it's in the cloud, as it's been mentioned, and that the exchanges, how they were foreseen at the beginning, are not necessarily relevant anymore? Maybe a first reaction from the audience.
I just wanted to say, as a non-European in my country, for instance, in my region, the Council of Europe treaties have actually played a very important part. We may not have been part of the negotiating process because we're not a European country, but we do take from that and as an important source of legislation, etc. And now that you're opening this up, I'm sure that there will be countries who will be asking for accessions. I just wanted to support that from a non-European developing country perspective.
Thank you very much. Our panelists. Before we come to the panel, would you like to say something? Okay.
Hi, my name is Patrick Ryan. I'm with Google. This is a great discussion. I have a question, and I'm hoping that it'll be discussed a little bit further. It was highlighted at the outline at the outset about the APEC principles, because we're seeing a world where there's essentially two different types of regimes. There's multiple regimes, but the two largest are the European model. And the APEC model, which has just recently been finalized as of a couple of weeks ago. It's entering an implementation phase. And I'd like to hear the panelists' views to whether these APEC principles, which are much more self-regulatory and co-regulatory than the European mindset would typically be comfortable with, whether these are complementary. Are they going to be part of a complementary regime, or are we going to see in the next couple of years a tension and some sort of a war of standards for privacy in this respect?
So just quick answer. The thing is, of course, at the edge of global governance, we cannot think with only one rule. We have to think at a multiple level, a multi-type of rule. So at this stage, yes, we saw this APEC regulation. It's very interesting. But also in Europe, we have also things called, in English, binding corporate rules, which allows multinational companies to exchange data across frontiers when they have multiple sets in many countries. But it's maybe different because when you're building a binding corporate rule saying that I am a multinational company, so I will have to transfer data everywhere in the world, you have to be allowed by the Data Protection Authority. So there is this still supervision of the Protection Authority, but it's also a kind of to work together between the companies, because it's much more easier than for a company to declare their treatment in each country. So the APEC model, at this stage, we will have to find if it could be complementary. So I don't want to give an answer this because we are still studying it at the CNIL. And also but it cannot replace, our point is, we will talk this after, for standards, the need, I think, for global binding standards. Something like Madrid Standards Convention 108 of Council of Europe. Something that set principles for the world. Then after, we can see how we implement those principles. So maybe we can use a mechanism of self-regulations, or mixed regulation between self-regulation and public regulation. But my point is, it cannot replace something global and binding. But I think we will talk after on this. Thank you.
I obviously know the APEC reform to a lesser extent. My understanding, however, is that the outcomes and goals are very comparable to the principles that are enshrined in EU laws. Therefore, having overarching global standards seems to be useful in order to achieve eventually some sort of mutual recognition of those different schemes. One tool which hasn't yet been mentioned, but which we were discussing in our prep, is also standardization processes in the more technical world, which is, for example, ISO, and there's a lot of activity going on currently in order to adapt current standards like the ISO 27 series to the challenges that we are discussing in the legal framework to get this into the standardization world, which would certainly also help in that mutual recognition process of those different ways of approaching the same goal, really.
I would like to come back to this issue in the third part, which I think is precisely the place to discuss the role of binding corporate rules and self-regulation in the general framework. I think it's a great question, but maybe we move forward.
The notion of transborder data flow, is there anything you would like to add on that in particular? Or because I also look at my watch, it's nearly 12:30, and we've already started going into this global standards discussion and need for. So shall we move to that now?
I'm happy to move to this now.
Yes, just 10 seconds. The thing is, I will say something in 10 seconds that can raise many debates, so please do not react immediately. So from our point of view, even if it's instantaneous, an information starts from a point A and will go to a point B, and that will cross border. So internet is not extraterritorial. Internet is the extension, in a sense, of our real societies. And if we don't try to consider now that there is no transborder, because if we say this, we will lose any competencies for some regulation. So, but that raises the question we will face now. There is a need for a global rule, because in any common market you build, any common space you live in, you need common regulation. So once you have said that, the challenge is among us now. Thank you.
I'd just like to very briefly remark that formerly the problem was companies having databases of some kind, transmitting an entire database from one country to another. That challenge, I believe, is mostly unchanged, and existing law can deal with it. But we now have a new situation with a new kind of data that just doesn't fit those old assumptions, that doesn't fit the old model, and we really need a way that a citizen in country A can force a company in a different continent to respect certain principles of human dignity with respect to their personal data. And that is missing. And it does not help just to have a good principle in the law of that country. You have to have the practical ability to actually assure yourself that the data is protected, that there is security, and that the company which violates its responsibilities actually will get punished.
I would have expected some reactions to that. No one? Yeah.
Yeah, I'll give an initial reaction if I may. I think a lot of this discussion is good. What I heard, and maybe I'm incorrect, but what I heard is that there is room for different kinds of standards, so long as a European standard is accepted by everybody. Right? And you know, maybe that isn't a conclusion here, but I think it's worth discussing a little bit. The APEC, countries represent half of the world's GDP, and there's very little overlap between the COE and the APEC countries.
Any other? Yeah, you have the.
Evan Burfield, I'm an internet entrepreneur from America. I mean, along that same line, I mean, this to me is probably the most practical and immediate standpoint from a business standpoint, actually trying to create companies, is that, you know, the market out there today is highly globalized. I can create an application that is available to almost anyone around the world instantly. But it's a tremendous hindrance on the ability to actually innovate and drive that you have such fragmented standards for data privacy around the world. And you know, an approach that's at least able to take the lowest common denominator, the most basic standards, and implement some kind of harmonization across different regulatory regimes would be tremendously useful for actually making cloud computing more practical and driving that forward. And you know, I'm new to the Internet Governance Forum, but you know, a lot of the very abstract principles around whether it's ownership or human dignity and all that is wonderful, but there's immediate issues that are sort of preventing a lot of commerce and preventing people from kind of distributing to the market in the way that they could.
And what I just would like to add to that, and something which again is related to our question, is really the legal certainty that businesses need in order to know which law actually applies in a given circumstance, and that is something which has caused a lot of uncertainty in processing the normal business. It is sometimes the case that there's this expression, you comply with the one set of rules, you're sure there's some infringement at the other end, and there is this catch-22 situation where you can't actually do it right. And so this really goes in the same direction. It is for business actually to be competitive and work in that space. You need to have that as this is one of the key issues, is get the applicable law really clear and easy to understand in all circumstances. And I think specifically in current revisions of frameworks, a lot of attention needs to be paid to that, because there is clearly, in the current situation in Europe, there's clearly laws that are competing in that space, which are not, where you can't comply with both. And that shouldn't be the situation for any business, and it doesn't help consumers either. Because then, at the end, a business can't really be transparent about what happens with the data if the law is not clear in that respect.
Let me just quickly jump in from the civil society perspective of being able to enforce rights. Obviously, clarity of law is fundamentally important to that also. Civil society organizations don't have huge budgets. So what can we do if we cannot even figure out which law might apply? Please fix this problem. I completely agree with my business colleagues on this one.
I don't know if we are back to the third question now, and I can move on with the minimum, how to ensure the minimum international standards. I guess the how to in our debate today should be the key question. We all agree, as far as I have seen, that certain new principles are needed, but the how to remains the hardest question. Well, all the issues we've been discussing have global relevance, but there is no global authority. And it has been mentioned justly that we do not have any, there's no legitimization behind EU to impose their concept of privacy on the rest of the world. From what I know, there are big discrepancies between how Europeans perceive privacy as some kind of social right and a very important public policy issue, as opposed to the US, where this is entirely individual right that can be waived by the individual with no much social relevance. I had the pleasure to talk to Daniel Weitzner last week about the US approach, and he confirmed that there is actually no chance that the US will move towards having a coherent data protection principles for many reasons, being that the lack of time to work on the huge framework they have, a very complex framework. So imagining that we I would like to have, of course, cross-border principles between India, EU, and US for many reasons, but it's a fallacy. I mean, we will never get there, or at least we won't get there in next 10 years. So it's a very serious question how we approach that and what other standards we might consider. Here coming the question of binding corporate rules and self-regulation. I'm aware that in the US, this is the main tool of regulating, namely the business imposes rules on themselves and then it gets enforced by the state. Well, it might be a way forward as long as consumers and civil society all around the world have this grassroots movement towards pushing the business in order to get the standards higher. I'm skeptical about it. I see interesting movements in the US, but I do not see the same movements, for example, in Eastern Europe and Central Eastern Europe, where I'm from, where the companies feel very much more powerful than the government, and they are more powerful. So we really have a serious issue. I'm actually more interested in your opinions on that because I don't have a good rule on that.
So we indeed switched to the last topic we wanted to address, which is need for global standards. Anton or Cornelia, your views?
Yeah, I think I've already made my point on the global standards. I just want to note that the European framework actually also allows for self-regulation, and it eventually business needs to be critical to itself, saying we could have more used that tool in the past. I think that was noted by also the Article 29 Working Party. There is tremendous, and that brings us really into what you said, just the tremendous cultural differences in how we approach legislation between the EU and US. And I wouldn't, from a civil society perspective, I wouldn't eventually not always be just critical towards what comes out of the US. I think there's some really good improvements going on in that space, and I pay a lot of credit to, in particular, the Federal Trade Commission, who is putting enormous efforts in advancing privacy in the US and really forces businesses to play along. And I think the current discussion around tracking protection, both in the EU and the US, is really showing and pushing companies like Mozilla or Microsoft and others towards technical solutions like tracking protection lists, for example, or do not track. So there is a lot of things really going on, and sometimes my feeling is that if we focus on some very specifics and then sort of find a solution that eventually really will improve the privacy more than only talking about high principles. So sometimes just going down to the root and solve the problem. And I think the example I just mentioned with tracking protection is really one of that. And we have in the Internet Explorer 8, for example, we started with in private browsing. And we have it developed, and that is really because of the public awareness, develop a further tool in IE9, which is the tracking protection list, which really helps. And it's actually not based on self-regulation from the business. It's really self-regulation from the society. They can decide what they want to have in there and out there. So it's a really powerful tool. And that is what technology can actually provide in that context. So we should not only focus on the one, but really sometimes focus on practical solutions as well.
Norbert, I don't know if you want to add something.
Thank you. I, of course, want to add something when you talk about international standards. I know that in this context, people think first about some kind of international agreement like a treaty. But let's not forget that there's something called an International Standardization Organization, ISO, and this does not only focus on technical standards in the narrow sense, but it's quite feasible there to develop standards defining very precisely, for example, responsibilities and how to exercise them in the context of data protection, various aspects of it. And if you do it that way, first you have an international standard. It's called international standard, and it is precise. It can be certified against, and then each country has the freedom to make that standard mandatory for companies doing business in that country. You could have an international ISO standard defining responsibilities for companies that have advertising-related data for good data protection. That in itself has no legal force, but it is developed in a transparent international manner. And then, for example, a country in Europe or a country in Africa, wherever, could decide to impose this rule. If you want to sell advertising to companies in my country, then you should comply to this ISO standard. And that is World Trade Organization compatible because it's an ISO standard. That's one way to implement international standards in a legally workable way, even without first getting everybody to harmonize their laws, which just isn't going to happen.
Thank you. Just one quick question. Who knows the International Conference of Data Protection Authorities?
Who knows? Yeah, everybody knows.
Yeah? So, okay, let's say, just to make a point that in 2009, as you all know, DPA from around the world, so much broader than Europe, they reached a consensus on standards. So maybe it's too unknown, but it's a very important step on global governance on privacy, because as I said, it's an international consensus. It's not the European that have imposed something to other people. So, but it's only a first step. The second step is in this multi-stakeholder world. The government, the only thing they do, they know to do is treaties, because it's the only tool that they will have to follow. Okay, it's just a memorandum of understanding or the soft law. They don't know. The thing is, if you want to be sure they will follow a tool, you have to create a treaty. But a treaty is, as the conference said in Jerusalem in 2010, is the objective. So we need to reach it in a few years to create a global principle for everyone. So previsibility for business and protection for users. So now everywhere in the world, the same law. But it's not the end of the story, because everyone will have to do his job. So that you cannot put anything in the treaty. Okay, you don't have anything in your constitution. That's impossible. Then you will have to enforce it, to apply it, with many ways. So standardization is a way. Corporate regulations is a way to do it. So it's a puzzle. But my point is, if some consider that you can achieve the puzzle and without this very important piece, the treaty is, and maybe the central piece, you cannot achieve this global standards that everybody needs now. So that's why we also encourage multi-stakeholder dialogue, because it will lead us to this goal. And we are not here as a DPA to say the treaty is the only solution. Okay, just create a beautiful treaty and all the problems will be solved. No, we need that treaty, and we have that one in a sense, because the Convention 108 of the Council of Europe is a really good start. And from a public authority point of view, now we have these Madrid standards made by DPAs, and we need to create that link with governments, because the DPAs do not create treaty, to create convergence from the public side. And we can also encourage the private sector to create those kind of convergences we have so in APEC. last week. So that's my point. Everybody has to do his job, and in the end, we will have a very good thing. Okay.
Thank you, Jeanette Hofmann, Social Science Research Center. I've been hesitant about speaking up because I'm not 100% sure yet what my message is. But the one thing I wanted to say is that one shouldn't put too much hope into standards, because unlike technical standards, it's very difficult to enforce standards on data protection. It's easy to cheat for everybody. So I don't think we can expect too much from standards. I've been having a conversation over breakfast this morning with somebody, and we both thought that for the private sector, this is an area of great uncertainty, because nobody knows what users of next generation will think. Will they think that data protection is cool, or will they think it's completely uncool? And what will actually determine this development? Nobody knows. At the same time, the business models of more and more companies depend so much on this crucial question. One potential development is an accident, like Fukushima in Germany. It caused a complete turnaround of government policies. The same could happen in that area. Don't have a clear idea of what kind of accident that could be, but it's a possibility that users' opinions and attitudes radically change because of some black swan kind of thing. So I think companies need to prepare for various developments in this area. To be competitive, they need to take into account that new business models might be built on strong data protection, so that the market plays a major role in creating new options for users, and users change their preferences and choices. And at the same time, this might not happen. So I would say one way forward is to give users more choice in this, to give them more transparency about what happens about their data, and allow them to interact with companies about what they want. I'm not sure this creates the degree of certainty all stakeholders would like to see in this field, but I'm pretty sure that standards or treaties won't do the trick.
I will have to quickly react to this. As much as I agree that standards is not the way forward, I think the picture, yes, the picture with okay, the thinking from the individual perspective is a kind of trap that I think we mentioned already. What I want to say is it all depends how you perceive privacy and data protection. Do you perceive this as purely individual approach or right, or do you see it as something more like a human rights issue, where you might have individuals consenting to processing their data, like youngsters, teenagers having no problem with this whatsoever, but from the broader perspective, you might see this as a social problem, and you might have this challenge of educating people. So when you say transparency, I think all of us agree that this is a necessity, but I would say it's not doing the job. We really need, that's my perspective, might be not popular perspective in the business, we need this accountability, data minimization, and proportionality principles that protect individuals even if the individual in question does not feel like getting protection. So, you know, we have the big challenge of whether privacy should be purely individual thing that you can waive, or we might see the state as somehow imposing the concept of privacy as important. I don't have good answer for that, but I see there is a big tension here, and I think Europe goes more towards human rights perspective, US goes more towards individual right, which might be not relevant anymore in the next generation. But I would fear that there is a danger in people choosing things without full awareness of what they are choosing, and us being unable to educate online.
Can I just clarify one thing? It's not that I'm against laws. I'm just not sure whether you can enforce them. I remember that in Germany, for example, for a long time we thought big companies, they all comply. Our problems are the small companies. And then we had scandals like those with German Telecom. Nobody could believe that such a big company would violate its own data protection rules to such an enormous amount. So you can, I mean, how do you enforce these rules, particularly if they're cross-border routes. I think that was what we need to take into account.
Just a quick comment. You know, at the CNIL in France, French DPA, we are only 150 people. So the thing is, our job is to enforce French data law and the European laws. So the thing is, that's why we talked about accountability, because we cannot stay on that stage and say, let's continue as it is, because things like that will happen again. With accountability, we can work before that in fully collaborative way between DPAs and companies to be sure that they will implement the process that will more protect our citizens in the end. But at a certain point there is also a material problem that we cannot see everything everywhere, but accountability can be a solution.
Let me just quickly jump in from the technical perspective. When a standard is too abstract, too high level, you cannot really enforce it, because it's not precisely possible to determine what you can do with it and what you should not be allowed to do. But when a standard becomes very specific, then you can actually certify against it. Many ISO standards are designed for certification, and you can get a certification, and there are penalties when you lie and that kind of thing. You can, in principle, do it. It just takes the will to do it. And if the governments say certain companies have to present this certification, and the government sends people there into the committees developing the standards to make sure that the certification actually means something, then you have achieved something. Short of that, we have only created a nice illusion.
I just have a really brief comment. I want to say that a lot of this discussion on standards and standardization in ISO is really healthy, and it's good to hear it from so many different people, because that is something that's practical, even if it's imperfect in many different ways. There's a lot of work that all of us can do, but this is a very healthy discussion. Thank you.
Well, thank you very much. Thank you for your patience. We've been very happy to share this with you today. I'd like to invite you tomorrow to the open forum of the Council of Europe, which is not specifically dedicated to privacy issues. It's the Global Internet Governance Strategy. Tomorrow morning at 10:30, you're very welcome. Thank you to our panelists. Thank you very much. I think we had a very good balance and mix of views. And thank you to the audience. Thank you.